Welcome to the Listen for Life podcast with Genevieve Richardson. Genevieve is a speech-language pathologist rehabilitating adults with communication challenges after a stroke or due to a neurological impairment. Get equipped with knowledge from experts in the field and professionals you need to know. We'll hear stories and experiences from others who are navigating life with aphasia. So, put your earphones in and take a walk outside. This isn't just a podcast. This is a community, a resource, and a support system. We're in this together. Do life.
Welcome, Keith Ludy, and welcome, VC Spears. Thank you so much for being here today. Our topic today is the legal stuff behind aging and perhaps what our folks need to know about and maybe some things they weren't aware of.
I'll just jump in with both feet, and thanks for having us on. We always look forward to the opportunity to try to educate people on maybe things that they're not aware of that maybe they need and they didn't know that they needed. Where we usually start with folks, of course, is a very familiar legal document that most everybody's heard of. It's a last will and testament. But not everybody understands why it's so important to have a last will and testament. A lot of it has to do with what happens if you need it and you don't have it. I've told many people before that when a person passes away, everything that they own is known as their estate. And passing ownership of that estate to who they choose, whether it be a spouse or children or somewhere else, can be fairly straightforward, or it can be kind of a bumpy ride. And so if a person has a last will and testament in place, it definitely creates some predictability regarding the timeframes and the costs that are going to be involved in order to transfer that ownership. If a person does not have a last will and testament in place, you don't have that predictability. It could go any number of different ways. And typically we tell people that you could probably expect the legal costs anyway to at least triple. And your timeframes could jump from relatively short amount of time to do those transfers to, upwards of a year, or even in some extreme cases, multiple years that you're still trying to legally pass along those assets. Some people believe that if you have a will that you have to take it through the probate process, and probate is when you take it in front of a judge and get it authenticated to carry out the terms of the will. It's not necessarily true. Many people have a will and it never actually sees the inside of a courtroom, but it operates on that theory of it's better to have it and not need it than to need it and not have it. The next two documents that I tell everybody that it's really important that you have, and this is probably regardless of your age or your condition, and that's your two powers of attorney. As long as you have the ability yourself to make your medical decisions and your financial decisions, you'll do it yourself. But what if the day came, either through accident or illness or something else, when you couldn't do that? Well, if you have a medical power of attorney in place, then you have a legal document that's going to designate the person of your choice to make those medical decisions for you. And the same thing with the financial power of attorney. Who's got the ability to access my money and pay my bills or receive funds on my behalf, or they could do real estate transactions on your behalf. So you want to have that person designated, because if you don't have those two documents in place and you had an accident or illness, the only other legal recourse would be to seek guardianship through the court system. The legal fees are astronomical. Your time in court in front of a judge is just going to be dominating your life. And even if the guardianship is eventually granted someday, you have to keep going back and asking the judge for permission for everything that you want to do on behalf of the incapacitated individual. I've compared it to entering into a lifelong game of mother may I, and all along the way, every time you go back to court, you're paying your guardianship attorney to draft all the documents that are necessary to file with the court. So the easy way to avoid that is to have a medical power of attorney and a statutory durable power of attorney, also known as a financial power of attorney, in place. They're relatively inexpensive, basic documents that you can get from any competent estate planning attorney.
What is different with a trust?
So a trust is a tool that many people will choose to use when they want to do everything that they can to avoid going through the probate process. The probate process, depending upon what state you're in, can be horrific, or it can just be bothersome, or somewhere in between. In Central Texas, our judges here in our local counties have done a pretty good job of streamlining the probate process. If you have a good will in place, you probably are only going to spend about 3, maybe 4 months going through the probate process. Some of that is just waiting on a court date, but it's fairly predictable and streamlined. I'm told that in some places like California, probate can be several years and involve a whole lot more money and a whole lot more time. So to answer your question about a trust is a legal entity that is created. Think of it like a bucket. And you're going to put your assets into this bucket. You're going to title those assets in the name of that trust. And then when you die, instead of having to go to court and get a judge's signature and have lawyers involved and everything else, whoever you've put in charge of that bucket, also known as your trustee, simply dumps out the bucket. And the reason people will do this and create a trust like that is because it's quick. I mean, you could dump out the bucket the very next day after someone passes away and distribute those assets. And it's also private. Not everybody realizes that when you have a last will and testament and you take it through the probate court, that becomes a public document that if somebody was nosy enough and wanted to, they can go online and pull up your will and see what you left to whom. A trust is a private document that is not built to see the inside of a courtroom. And so your trustee would simply distribute your assets quickly and privately. That's the biggest difference, is one is made to go inside of a courtroom and the other is made to avoid going inside of a courtroom.
How does a family decide between the two? Is there a financial decision that they have to make where one is significantly less expensive than another? Or what other considerations do they have for that?
I think cost usually will play a big role in it. A basic will is going to cost a lot less than a trust is. Now, legal documents are one of those things that it depends upon who you're asking to draft the documents for you. There's not a set rate. I say shop around and try and find an attorney who's willing to, and that they've got a long track record of drafting trusts, and this isn't their first one. That is usually one of the deciding factors. Thinking about places like California, where time is the big element, I'm told there. I'm told people who move to Central Texas from California, and we have quite a few, will tell me that they got a trust and it wasn't the money issue, it was the time issue. And once they come to Texas and we tell them, hey, our probate process is 3 or 4 months, many of them will decide, you know what, we're just going to go with a will here instead of a trust. Some combination of time and money.
Well, I think the privacy in the trust is an important factor as well, because your assets become, in a public document.
Yeah. The other thing about the trust is it depends upon the type of trust that you're looking for. The first type is simply called a revocable living trust. Some people know it as a family trust. And they're fairly common. And the reason people get those is exactly what we've been talking about, the speed and the privacy. The second type of trust that is very common, it's referred to as a supplemental needs trust, or some people will call it a special needs trust. Those are very useful if a family has an adult child who maybe has special needs, and the family is taking care of that adult child, of course, but they want to have some type of plan in place as they age. What happens when I die to my special needs child? I want them to have access to any and all funds available through government programs. But if I leave them my money in a will, then they're not going to be eligible for those government funds. So a supplemental needs trust is the answer to that problem, where you, again, using the analogy of the bucket, you put the assets into this bucket and you name somebody else, many times it could even be a sibling of the special needs child, put them in charge of that and say, look, this money is to take care of your sibling, but the sibling, the special needs child, never legally owns those funds. So therefore, they're not disqualified from some of the government programs. And the third type of trust, and this is the one that VC and I in particular do a lot of, is called a Medicaid Asset Protection Trust. And a Medicaid Asset Protection Trust can be the difference between people having to spend down their life savings or not before they can qualify for certain government programs through the VA if they have a military tie-in, or through Medicaid.
Is that something available in all states, or is it just for Texas?
Medicaid is available in all our states, but each state has their own state plan. I know the rules for Texas, and I can certainly advise you on those rules. Some are similar, but then some are very different. So it's kind of hard to generalize that. In Texas, there's a tremendous benefit to having your assets placed in a Medicaid trust. And if you do it 5 years before you have a need, then there's no look back on transferring those assets. And so you still have whatever you want to leave behind for your family members. You still have those available to them and accessible to them. It's there by design. You know, the legislature has to pass all our rules for the Medicaid program.
Keith, please tell us again the name of that trust.
It's called a Medicaid Asset Protection Trust. It is a type of an irrevocable trust as contrasted with a revocable trust. Like the family trust is a revocable trust, which means that you set up that trust and you can change it as often as you like. An irrevocable trust is a little bit different in that I compare it to maybe building a brick wall, that you're gonna use pretty solid stuff and put it in place, and you're not planning to change it or tear it down. There, of course, are ways that if you absolutely had to, you could, but you're not creating it with the idea that, oh, we'll revisit this once a year and see if we need to tweak it a little bit. It's with the goal of trying to make them eligible for Medicaid benefits without having to spend all of their life savings. The idea behind it is that this type of trust, Medicaid cares about your countable assets. And this type of a trust can convert countable assets into non-countable assets under Medicaid rules.
There are a lot of rules. There's a lot of subtleties, and you always hear you need a will or you need a trust, but you both have been able to illustrate that there's a lot of shades of gray. How would someone determine if they want to do a will or a trust? How would someone find the right attorney for them that's going to help them get these legal documents in place?
Well, first of all, I tell them if you're in Central Texas, call us, of course.
Well, of course.
If you're in another part of the state, we also do Zoom calls and phone calls, and we can help people who are not actually living in Central Texas. I usually would start with the most state bars where all the attorneys have to register will have something on their website that would allow you to say what type of an attorney that you're looking for. And many of them will even give you a list of attorneys who practice in that area in the Chief Disciplinary Counsel's office. That is the office that is responsible for bringing discipline to the profession and punishing attorneys who do unethical things. I bring that up because that information is available through a search engine on the state bar website in whatever state you're in. If you're thinking about going to see an attorney, I encourage people, first, look up their disciplinary history. Make sure that you're not stepping into a hornet's nest of trouble. Probably 95% of the attorneys out there are honest, hardworking people, just, trying to help folks and make a living. It's those other 5 that you got to look out for. Their names keep popping up over and over again. Depending upon the complexity of what you want to do, I think that if you just need a very simple will, there's a lot of attorneys that will be able to help you with that. If you are really wanting to develop an estate plan, and this doesn't mean that you have a whole lot of assets, but you want more of a big picture planning, I would say look for somebody who actually advertises that they do estate planning or elder law. And if you are trying to become eligible for Medicaid benefits, don't go to an attorney who doesn't know Medicaid. That is definitely a field that is very complex, and it's easy to get lost in the jungle if you don't know what you're doing. So look for an attorney who has been around the block a few times with that and can answer your questions, because there are decisions to be made that are life-altering decisions when you start moving assets that you saved your entire life. Find somebody who listens to you. Find somebody who's going to take the time to explain and answer your questions and have time for you and not just shuffle you out the door because it's time for the next appointment. Those are the kind of people that you want to entrust with something as important as the topics that we're talking about.
Does the planning for the will versus the estate change throughout a lifetime, and accomplishments and assets?
That's a question that comes up frequently. People will ask me, hey, my son or daughter just turned 18. Do they need a will? Do they need power of attorney? And I tell them, well, okay, it's a trick question, but the answer is, first of all, tell me about their assets. If they are independently wealthy at age 18, then yeah, we need to probably do a little more estate planning than if they have a part-time job at a fast food restaurant and that's their entire income. From the time a person turns 18, I'd like to remind parents, when you send your kids off to college, that they may not need a will if they don't have assets, and they could use a financial power of attorney, certainly, but I would not put that in the crucial stage. What I would put in the crucial stage for that kid going off to college who's 18 or 19 years old is a medical power of attorney. Okay. You absolutely want your college age kids, if you're sending them off to college, to sign a medical power of attorney. Why is that important? Well, you still see your 18-year-old, and I have an 18-year-old, you still see them as your child, but the law says, no, that's an adult. If the worst case scenario happened and you got the midnight phone call from somebody at a hospital saying your 18-year-old or 19-year-old is at the hospital, there's been an accident, and you throw on your slippers and rush out the door and get to the hospital, and you walk in and you say, my baby, where's my baby? And the doctor's going to say, that may be your baby, but that is a grown adult. And unless you have medical power of attorney, I can't share any information with you. And at 1 o'clock in the morning, when you're standing there in your slippers, is not the time that you want to suddenly go, you know what, I should have gotten that medical power of attorney for my college kids. Once a person is out and earning a living, okay, great time to get a will and great time to get the durable power of attorney in place. When you get married, of course, you would want to revisit all of that, because now you have 2 people potentially earning and assets to divide up. When you start having kids, there's another document that you'll want to consider getting, and that would be a designation of guardian in the event of your illness. Now, your will is going to address the issue of what happens if I die, who's going to raise my kids. There's not anything in the will that addresses what happens if I'm in an accident and I'm in a coma, but I'm not dead. Who's got legal authority to go enroll my kids in school or consent to any medical procedures that they might need? All the things that parents do, all those decisions. The designation of guardian, there would be a court hearing involved where a judge would actually make those decisions. You know the people in your life. You know who's trustworthy. You know who would raise your children according to your values and standards. And so you want to have that document in place to speak for you if you cannot speak for yourself. again, in the event that you're alive, but you can't care for your children at the moment. The next step comes when people start purchasing their house. And that's a document we haven't talked about yet. And it's actually one of my favorite documents we have here in Texas. And it's called a ladybird deed. Other states have something very similar called a transfer on death deed. The idea behind the ladybird deed and the transfer on death deed is when you die, if you own real estate, at some point, somebody has to sign a deed deeding your ownership in this real estate to somebody else. If you left your ownership in that real estate in your will, then it would come at the end of the probate process. The ladybird deed is meant to skip around all of the court and probate and make that transfer happen very quickly. Typically, just as quick as you could get a death certificate down to the county clerk's office. And that's usually 3 or 4 weeks. Why is that important? Okay. Imagine this scenario. You have a young couple in their mid-30s. Suddenly, one of them is killed or dies unexpectedly. Now you've got a surviving spouse who's trying to take care of the kids, doesn't have enough money from their own income to pay the mortgage, and so says, well, I guess we better go put the house on the market and sell, but they can't put the house on the market because if they're in Texas or another community property state, each spouse owns one half of that house. So when the first spouse dies, the house is now owned by the surviving spouse, still owns their half, and the deceased spouse estate owns the other half. And so the surviving spouse cannot sell the house when they only own half of it. And if they have to wait to go through the probate process, that's going to be, at least around here, 3 or 4 months down the road. Ladybird deed doesn't bring back the spouse, which is the real horror in this story, but it does allow the surviving spouse to get custody, full ownership of that house within 3 or 4 weeks. When you get to the point where you have a house, you need to think about the fact that, especially if you have a mortgage on that house for a young couple, get a ladybird deed, transfer on death deed, put that on the house, and do everybody a favor in your family so that they're not having to wait. There's 2 other documents I haven't mentioned yet, Genevieve, that people, we tell them that everybody could benefit from having this just because they solve problems that you don't really think about. And the first one is what's known as a physician's directive. Some people refer to that as a living will. That's a document that can prove to be very important if something ever happened and you were on life support and your doctors were saying, look, the reason that you're still living is because we have you plugged into the wall. The doctors don't want to face the scenario where they walk out into the waiting room and tell the family, look, sorry, but this is the way it is. What do you want us to do? Because invariably the family is going to be divided. The one person whose voice really should matter in that moment should be yours because it's your life. Under what circumstances would you want to remain on life support? Do you want them to delay if the doctors are determining that you're not coming back, you have no brain waves, and the doctors are convinced? Do you want them to then start sort of a ticking clock and say, okay, well, wait 48 hours or 72 hours before you disconnect my life support, just in case the doctors are wrong or a miracle happens? That document takes the burden off of your family members. Nobody wants to be the one to tell the doctor, okay, do it. And so it's an important legal document to have. The other one that we haven't mentioned yet is called a disposition of bodily remains. And we find that, not surprisingly, many people will pass away and their loved ones all look at each other and say, do you have any idea what mom or dad wanted us to do here? And they said, no, it never came up over the dinner table. Well, this is a legal document where you can express your wishes. You appoint an agent to legally be in charge of your remains. Usually it's a close family member of your choosing. And in this document, you can express what your wishes are. Some people feel very strongly about that. Some people don't. We've occasionally heard of stories of people where, especially if you're dealing with somebody maybe who's got fighting dementia and they're saying different things to different people, and then they pass away and the family members are now arguing that no, they told me they want to be cremated. No, they told me they want to be buried. What are you going to do? So this breaks all of the ties or in confusion. And by the way, I mentioned dementia and Alzheimer's. That we're seeing more and more of that, I think. And whenever I hear a family say that they had a loved one diagnosed with dementia or Alzheimer's, I tell them, think about the fact that there is a window of opportunity that is closing. We don't know how quickly it's closing, but there is a certain amount of time a person has to sign legal documents before they're unable to anymore, because you have to be able to understand the documents that you're signing. And once they lose that ability, you may be stuck.
All of these documents need notarization. Can you download documents off the internet, get them notarized and hold on to them? Do you have to go through an attorney for all of these things?
Yeah, great question. I've seen a lot of people bring documents into us and they say, well, look, we're ready to have attorneys do it, but here's what we prepared online. And I just can't tell you how dangerous that is. If you don't know what you're doing to be preparing legal documents, because it's not only what's on the page, but it's what's not on the page. A lot of these places and companies that sell these things online or even offer them free online are trying to reach a mass audience, and they're not state-specific documents. And so they won't have those little nuances in there. And if you don't have those nuances, you really don't know what you have. I would say at a minimum, if you're just determined that you are going to try to do this yourself, at least take them to an attorney and let the attorney look at them and tell you what you really have, because so many of these documents, by the time you use them, you might be deceased or unable to sign a new and better one. It is well worth your time to get somebody who's experienced and do it right, because you can't afford to get it wrong.
Yeah.
One other document I want to be sure that we talk about, because there's some confusion about it, and that is the DNR, the do not resuscitate.
I would have thought that had something to do with a physician's directive.
No. And many people confuse these two documents. Remember, the physician's directive or directive to physicians only deals with what happens if you're on life support. Do you want to stay plugged in or not? Very basic question.
Okay.
The DNR is a document. Many people will come to us when they schedule their appointment. Our paralegal will tell them, bring any legal documents that you have from the past and let us review them. And very often included in that pack of documents that people bring, there'll be a DNR stuck in there. And I'll ask the person, I'll say, did you have surgery by chance? And it doesn't even have to be serious surgery. It could be having your tonsils out. And they say, yeah, how'd you know? And I say, because you have a DNR. And it's very common right before you go into surgery, when you're signing all these papers, that they'll put a DNR in front of you. And DNR, of course, stands for do not resuscitate, which means that if you flatline when you're in surgery, and they're unable to bring you back, I guess that would be exhibit number 1 that they present in court at a medical malpractice trial, saying, well, they didn't really want to come back. They signed this DNR. But people get out of the hospital and they keep that DNR because they think it's a valuable legal document. And I tell them, once you're out of the hospital, shred that thing. Do not keep it. Do not include it with all of your other legal documents, because if hypothetically you're walking down the street, perfectly healthy person, not a care in the world, birds are singing in the trees, and you have your DNR in your pocket and you tripped on the sidewalk and hit your head and had a cerebral hematoma or something like that, went into cardiac arrest. If you have a DNR there and the ambulance shows up what you're telling them is, do not resuscitate me. Even though you may have another 50 or 60 good years to live, and they could have saved you,
Wow.
you've got a legal document that they are being told not to. And now I've talked to some ambulance drivers before, and how seriously they would take that in the moment. And there are different factors that depend, but it's not a document you want to have around unless you are, as VC says, you're ready to go to heaven. In almost 20 years of practice, I've had 3 people who came into my office with a DNR and left with a DNR, and I didn't talk them out of it. One of them was quite elderly and was just explained to me that pretty much everybody who had mattered to them had already passed away before them, and they were ready. And I said, okay, well then you maybe want to keep your DNR. And I had another one who had been fighting terminal illness for a long time and was just tired of the fight and the pain and everything that comes with that. And oddly enough, I had one, it was just earlier this year, in fact, it was a 63-year-old woman who was in perfect health. And she said, well, it's just down to me and my daughter, and she lives out of state, and we rarely see each other. And I'm just kind of getting through the days. And if the good Lord wants me tomorrow, I'm ready to go. And I said, well, okay. As long as you understand what you have, that what you're telling doctors is, even if you have the ability to save me, don't. So if you're not at that point in life that you're not wanting doctors to save you, you do not want the DNR. Tear it up, get rid of it.
Does a notarization make a document legal? Do you have to have a notarization on documents you're referring to?
Sure. Yeah. And I realize you're speaking to people in different states, and so
yeah, I know. Right. We'll speak about Texas, since that's
speak only about Texas, but now it depends upon the document. In Texas, a will, for example, needs to not only be notarized, but have 2 independent witnesses who are not beneficiaries under that will. And with your powers of attorney, you can do those either with 2 independent witnesses, or you can do them with a notary. And by the way, a notary is not doing anything other than saying, when they stamp and sign their name, that I verified that the person whose signature appears on this document is who they said that they were. Gotcha. It's not an imposter. So that's the job of a notary, is they check the identification and they watch the ink hit the paper from that person. They're not even the ones verifying if the person truly understood what they were signing. That's up to the lawyer to do it. I mean, a lawyer would be unethical if they let a client sign something and they weren't convinced the client knew what they were signing.
Got it.
For attorneys,
if you are married and seeking Medicaid, it works to your benefit. In order to qualify for Medicaid, without any estate planning, if you don't know what's available to you, what would happen, what we tell people is, if you take the time and meet with somebody who understands how the system works, you can set up a Medicaid asset protection trust. And even under a worst case scenario, like a stroke where something needs to happen quickly, you could probably preserve between 60 to 65% of that money and not have to spend it on private paying for the room and the care that he needs. So I say all that because these are not small numbers that we're talking about. If you can utilize one of these Medicaid asset protection trusts. And by the way, if you're planning ahead 5 years and 1 day, to be exact, ahead of the curve, and create this trust and put the money in it, then it's not 60 to 65% of the money that has been converted from countable to non-countable. It is 100% of the money. Sometimes it helps people perspective-wise that it's really worth your time to sit down with somebody and say, hey, is this an option for me? I'm very interested in saving as much of my nest egg that it took me so long to build as possible, so that my children and my grandchildren can enjoy it.
That also makes extra money available to the family members if they have extra things, like maybe speech therapy, that they want to pay for them. that they're not offered at the nursing facility because they will have to, Medicare and insurance only pays a specific number.
But it takes planning. That is the take-home message.
Absolutely.
And overseeing the money that's in this trust and helping with it understands how to invest inside of this type of trust. It's a little bit different than ordinary investing. There are things that you need to know of how Medicaid is going to look at different things. But the goal, of course, is that you put your money in one of these trusts and it grows, so that instead of at the end of your life, you're down to your last $2,000, maybe you're got 400,000 plus what you invested. I don't know how much it could grow. It depends upon the markets and everything. But wouldn't it be wonderful to actually put money into a trust? And when you die, there's more money in the trust because you invested wisely than you ever even put in there. Instead of the opposite, if you're just paying out of pocket and not doing the smart things, then you're going to have a lot less money to leave to your family or have available.
Absolutely.
So much great information. I want to thank both of you for your generosity with your time today. I know I have learned so much.
I'm honored to be able to help anyone. It's just certainly my pleasure.
Thank you.
For our audience that's local and may have more questions, feel free to contact us. We will sit down. We'll schedule a time here at our office to sit down with you and talk about your individual situation. We just want you to be educated, have the information, and make the decisions that are going to be best for you.
Thank you so much.
Thank you.
Thanks for tuning in to the Listen for Life podcast. We hope you feel empowered and supported. Head over to listenforlifepodcast.com to see the show notes with links and information from today's episode. Do you have a topic, a resource to share, or a guest recommendation? Inquiring minds want to know. Let us know in the comments section. Wishing you a fabulous week.